Friends, this is the 64th Friday group meeting. The today's speaker is Madam Indu Malhotra, Senior Advocate. The topic is Bilateral Treaty Arbitration. I'm happy to hear Indu Malhotra ji. She, second lady, as elevated, designated by this court as a Senior Advocate. We are all proud of her. Madam, now I request kindly initiate your subject. We are all grateful to you. Now I request Pawan Kumar Singh will read biodata CV of Madam, please.
First of all, I'm thankful to Mr. Rao for giving me the opportunity of reading out this biodata of none other than our beloved senior colleagues at the bar, Ms. Indu Malhotra. She has been a senior advocate practicing in the Supreme Court of India and High Court since the past 34 years. She was the second woman to be designated as a senior advocate by the Supreme Court of India in 2007. She has specialized in the law of arbitration and appears in various domestic and international commercial arbitrations. She has been appointed as arbitrator by various arbitration institutions in India. In 2016, she has been appointed as member of the High-Level Arbitration Committee constituted by the Ministry of Law and Justice, Government of India, for the review of institutionalizations of arbitration mechanism in India. She is legal. As talking about her legal professions, in 1983, she got enrolled herself to the Bar Council of Delhi. In 1988, she took the Advocate on Record examination conducted by the Supreme Court and was awarded Mukesh Goswami Memorial Award. She appeared in various domestic and international commercial arbitration in India and overseas. She also appeared in proceedings instituted under the Arbitration and Conciliation Act 1996 before various courts. Some of the multinational companies represented by her include ANZ Greenlace Bank, KPMG, Agilent Technology, Medtronic, PepsiCo India, Indian Olympic Association, Vedanta, to name just a few of them. Her academic and publications are as follows. In 2005, she was nominated by the Chief Justice of India in the category of eminent persons as a member of the General Council of Gujarat National Law University, India, established under the Gujarat Law National University Act. To her publications, she has in her name Commentary on the Law and Practice of Arbitrations and Conciliation, 3rd edition, Res Judicata Arbitration, Fast Track Arbitrations. She is currently working on the 4th edition of the Commentary on the Law and Practice of Arbitration and Conciliation, which will be published in 2018. Currently, she was nominated in 2016 by Ministry of Corporate Affairs to the Central Council of Institute of Chartered Accountant of India, a statutory body established under the Chartered Accountant Act. She was also had the privilege of heading the Supreme Court Sensitization and Internal Complaint Committee and trust of the Safe. She was also part of the trustee of the Safe Life Foundation, a non-governmental organization formed with the object of prevention of road accident and formulating a system for providing immediate post-accidental response to save the life of victims. With these words, I welcome you, ma'am, to the Friday group discussions.
Before beginning, madam, this normal hour, we will introduce ourselves. I am Shishkira myself. Then
I am Ridula.
quickly.
Madhurima Tadi.
Pawan Kishore Singh.
Rahul Agarwal.
Abhishek Shukla.
Please, backside. Come. Introduce yourself, please.
Hema
Biju. R.D. Narwal.
Quickly.
Nandini Sen.
Naresh. Yeah, before beginning, come Inakshi Upadhyay, can you give a bouquet of flowers to our madam? It's a great help. Yeah, please, madam.
Good afternoon, colleagues. I am thankful to the Friday group for inviting me to speak on investor-state arbitration. Now, this is an offbeat topic which people who are engaged in litigation are completely unfamiliar with, because this is a kind of arbitration which does not culminate in the national courts at all. So I thought it was, and since today, currently India is facing 23 bilateral investment treaty claims, and there are some which have already culminated into arbitrations, some which are at the claim stage and Government of India is trying to negotiate with the claimants. I thought it is an issue of great relevance, and I thought familiarity with this issue was very, very necessary, because each of these claims runs into $100 billion. They are tried by investment treaty arbitration tribunals overseas, and these claims are made by foreign investors against the government of the state where an investment is made. So I propose to just give you an overview through a PowerPoint presentation which will familiarize those who are not familiar with this topic and give you an overview of how the land lies for the Government of India. Now, investor-state arbitration, they are conducted basically under a bilateral investment treaty, that is a treaty which is entered into between two sovereign states, or a multilateral investment treaty. For instance, if India is a signatory to a multilateral investment treaty, then automatically investment treaty arbitration can be invoked. The third is foreign investment law. Now, this is a different kind of arbitration. It is also known as arbitration without privity, because we are familiar with the Arbitration Conciliation Act, which provides for consensuality, that both parties should have conceded and should have been a party to the agreement, etc. But insofar as investor-state arbitration is concerned, it's considered to be arbitration without privity, which means that there may not be privity between a foreign investor and the sovereign state where the investment is made, but it emanates out of a treaty obligation between two sovereign states. One sovereign state is the state to which the foreign investor belongs, and the other is the co-state where the investment takes place. The national courts do not have any role to play. Now, there has been an exponential growth of bilateral investment treaties since 1980s. By I think end of 1980, there were 385 BITs in force, and by 2016, there are today 2,950 BITs which are in operation world over. India signed its first BIT with the UK in 1994. That was our very first BIT. And this actually came when India started encouraging, when we opened up the economy and we wanted foreign direct investment for development of infrastructure. So in the 1990s, we entered into our first BIT with the UK. Thereafter, India has signed BITs with 84 countries based on the 2003 model. There have been two models. One was the 2003 model, and recently we have come out with a new model in 2015. I'll come to that in a little while. And the inflow of foreign direct investment into India increased from US dollars 4,029 million in 2001 to 46,556 million in 2011-12. After 2011-12, there has been a downward trend of foreign direct investment. It has fallen to US dollars 36,046 million during the year 2013-14. In fact, actually, today governments have started feeling with these huge claims being made by foreign investors against developing states that is there empirical evidence to correlate foreign direct investment with infrastructure growth. So there has been actually a lot of doubt because there has been a dip in the FDI since 2013-14. This is in fact a reason why sovereign states are now intending to review the entire situation. Now, what is the purpose of an investment treaty? An investment treaty is to provide stability and predictability in order to foster an investment friendly climate. It encourages foreign direct investment. 2015 FDI from developed to developing world total about 681 billion US dollars, and this was meant to provide essential infrastructure. The disputes between an investor and host state are distanced from the investor's home state and the host state. I'll explain a bit. These investment treaties, actually, why did they come to be signed by sovereign states? There were cases where developing states would sometimes nationalize the investment. So the foreign national felt insecure and apprehensive about the protection of their investment. So as time evolved, and earlier states used to be provided aid by other states, but there was a huge debt which started taking place and states felt that they could not recover this money. So it actually, as evolution took place, it was the ICSID was, that is the Indian International Council, which is attached to the World Bank. They came out with a uniform system of bringing about investors having the right to sue the host state if their investments were jeopardized. And that's how these treaties came to be signed right from the opening of the economy. It was in the 80s and 90s onwards in India, it became more common. Now the forum which have conducted these arbitrations they are normally institutional, ad hoc are very few. The lead institution which is carrying out investor-state arbitration is ICSID, which is the International Center for Settlement of Investment Disputes. This is attached to the World Bank and it came in with the Washington Convention. The second one is an additional facility where one party is not a signatory to the ICSID Convention. Let me stop here for a minute. India has not signed the ICSID Convention at all because frankly speaking, the ICSID arbitrations are very, very stringent. There is no second look at the award, even if there is a bias or anything. They are extremely stringent. And thirdly, what developing countries have recently started feeling is that there is a bias in favor of the foreign investors against the developing states, and huge claims have been made by some of these arbitral tribunals. But ICSID is the most commonly used for international arbitrations. The third one is Stockholm Chamber of Commerce. I've actually enlisted these in terms of volume of work. The most common is ICSID. After that, additional facility, Stockholm Chamber of Commerce, ICC, the LCIA, the Permanent Court of Arbitration at The Hague, which is one of the oldest institutions, I think it's over 100 years old, which has traditionally carried on state-to-state arbitration, but investment treaty arbitrations are also being conducted by them. And India, in its model BIT of 2015, has named the president of the PCA to be the appointing authority. So it's of relevance to the government of India. Then India also conducts its BIT arbitrations, which are ad hoc by utilizing the UNCITRAL rules, which are being utilized by us. And now the Singapore International Arbitration Center of late has started conducting also very, very recently, I think since 2017, they have started also conducting BIT arbitrations. These are the forum worldwide which are used for investor treaty arbitrations. Now, where does the jurisdiction come from? In the treaty, you must be, a foreign investor must be a protected investor. The term investor, investment and the obligations are all spelled out normally in a treaty. So you should be a protected investor, you should have a protected investment, and the state should have acted in breach of the treaty obligation to enable a foreign investor to sue the host state. A protected investor can either be a natural person or a legal entity, that's a corporate entity, depending on the treaty in question. Normally they both are. Then I want to take you through what is a protected investment. Investments are typically defined in very wide language with inclusive examples. The issue of interpretation will be with respect to the definition of investment which is mentioned in the treaty. I have set out for you all the two models which India had come out with, and I want to read them to you so that you can understand it in the Indian context. India's model BIT 2003 was extremely widely worded, and maybe that was also one of the reasons why such a large number of claims have been filed against the Republic of India, because of the wide definition given to investment. Under the 2003, now let me tell you, this 2003 model BIT has been scrapped. But I want to tell you how was investment defined under the 2003 model BIT and how is it defined by the 2015 model BIT. The 2003 model BIT said investment means every kind of asset established or acquired, including changes in the form of such investment, in accordance with the national laws of the contracting party. 1. Movable, immovable property as well as other rights such as mortgages, liens or pledges, shares in and stock and debentures of a company and other similar forms of participation, rights to money or to any performance under contract having a financial value, intellectual property rights in accordance with the relevant laws of the respective contracting party, business concessions conferred by law or under contract, including concessions to search for and extract oil and other minerals. Now at this point of time, why did we put this extract oil, other minerals? India had reserves, India wanted technology, so it was a very widely worded definition. Now India has scrapped this 2003 model BIT after 23 claims were instituted against the government of India, each of them to the tune of almost $100 billion. We have now come out with a 2015 template for negotiating fresh treaties. We have scrapped our BITs, the existing bilateral investment treaties with I think almost 59 countries as at present, and we are in the process of scrapping others also, and to renegotiate fresh treaties, because the earlier 2003 treaty, if you saw, the definition was very widely worded. The 2015 model BIT, you will see now how guarded we have become. It's once bitten, twice shy. You have to be careful because a widely worded BIT can take you anywhere. The claims are huge. Now this one is qualified. It says investment means an enterprise in the host state, constituted, organized, operated in compliance with the law of the host state and owned or controlled in good faith by an investor. Then it says for greater clarity, investment does not include the following assets of an enterprise, and then it enlists 9 of these items which are not included by the term investment. It says any interest in debt securities issued by a government or government owned or controlled enterprise, or loans to a government or government owned or controlled enterprise. Any pre-operational expenditure cannot be claimed. Third is portfolio investments are not included. Claims to money arising solely from commercial contracts for sale of goods or services, because that's completely commercial. Why do we enter into investment treaties? We enter into investment treaties so that the foreign investor brings in foreign investment into our country to help in infrastructure. It comes for a substantial period of time, and there is a substantial amount, and there is a commitment to the growth of the country. It can't be a pure commercial transaction for which you are making a claim against the government of India Government of India means the Republic, people of India, because it goes out of the taxpayer's pocket if we lose. Then goodwill, brand value, market share or similar intangible rights. Claims to money that arise solely from extension of credit in connection with any commercial transaction. Then I'll stop at 7. I do want to read it and explain it. Any order or judgment sought or entered in any judicial, regulatory, administrative or arbitral proceeding. Why has this come in? There is a background to it. India has lost in the white industries. That was the first BIT arbitration where an award was passed by an international tribunal against the government of India for over 4 million Australian dollars. What was the basis of the claim? The basis of the claim was that white industries had filed an ICC arbitration against Coal India. They won in that arbitration. They came to India to enforce it. The matter was pending in the Supreme Court for 9 years. So they started a bilateral investment treaty arbitration in which they said that we must have effective means to assert our claims, and they went and filed a bilateral investment treaty against the government of India for not being able to enforce that ICC award for a period of 9 years, and that was awarded and government of India paid that amount. So that is why Roman 7 has been now included, that an order or judgment entered in any judicial, regulatory, administrative or arbitral proceeding is not included. So you can't use the BIT method to come and enforce your claims in India. That is not any longer covered by the treaties. Then we come to Roman 8, any other claims to money that do not involve the kind of interest or operations set out in the definition of investment in this treaty, and for the purposes a holding company or an investment company shall not be considered an investment, nor shall such companies be considered as protected assets of an investment. Now, what is the distinction between protected and unprotected investments? In one of the leading arbitral awards, which is known, it's one of the most well-known awards, which is called Salini versus Morocco, they said there are 4 main attributes of a protected investment. The first is it should be a contribution of money or assets by a foreign investor. There should be a minimum duration. It can't be that you come for 2 years, you try to commercialize, make a huge amount of gain and then say that unprotected. No. You have to come for a substantial period of time. You must be committed to the host state. Third is there would be an element of risk. Fourth is a contribution to the economic development of the host state. That is what is provided by an investment treaty, because the state cannot barter away the rights of individuals by only on commercial basis. It must be a commitment for the economic development of the host state. This ownership may be direct or indirect, and of course it provides for investment structuring to allow companies to take advantage of BITs. So they do allow a parent company, subsidiary company to provide that kind of restructuring is permissible. Now the substantive protections under a BITR, there are 5. One is fair and equitable treatment being provided to the foreign investor. Second is unlawful expropriation. Third is full protection and security. Fourth is no arbitrary or discriminatory measures. And fifth is national treatment and most favored nation treatment. I'm going to explain each of these concepts. I thought I'll first tell you which are the 5 substantive protections which a treaty provides. The first is fair and equitable treatment. This standard has been the subject of divergent interpretation by various tribunals. It requires a home state to maintain a predictable environment which is consistent with reasonable expectations. It is, for instance, I'll tell you, and by way of an illustration, 2 countries enter into a treaty. The host state where the investment is made, they say for 20%, that is the duration of your contract, we will not change the taxation rate, because they want to encourage them to come and invest in our country, and that means a predictable environment. Because suppose we go into a heavy taxation binge It can completely wipe out an investment. So that is providing a predictable environment consistent with the legitimate or reasonable expectations of an investor. Second is the content of the standard is broad and flexible. FET was protection to be provided under customary international law minimum standards. So this has actually, it was in customary international law and it's incorporated as a part of BIT standards. The next one, and there are some examples I've given you. FET includes stable legal and economic framework, impact on an investor's reasonable expectations, the arrangements upon which an investor was induced or invited to invest, and effective discrimination in favor of domestic entities. This would be violative of the fair and equitable treatment. Then unlawful expropriation. What is unlawful expropriation and what is lawful? Because lawful expropriation can be a sovereign function also, you may require to do it. But when is it unlawful? When does it become a ground for making a claim under a bilateral investment treaty? I've spelled those out. A frequently relied upon protection against expropriation without prompt, adequate and effective compensation. There are two kinds. One is direct and one is indirect. Direct is overt, formal taking over of the asset of the foreign investor, for instance by nationalizing the asset. By a process of nationalization, you just take over the asset. Indirect is covert, a measure that neutralizes the enjoyment of the property. For instance, if you impose heavy taxation, you will neutralize the enjoyment of that investment. When is it lawful expropriation? Because we are a sovereign state, we may need to take many steps for the welfare of our country. For instance, I have set out what is lawful expropriation. It has to be for a public purpose. It is expansive and rarely challenged. It should be non-discriminatory, means you can't be discriminating against the nationals of another state. You should utilize due process. You must give adequate notice and follow broad principles of natural justice. So following due process. And fourth is, it has to be accompanied with compensation. That's fair market value. If you are taking over an investor's asset, you have to provide them fair market value, and you can expropriate an investor's investment for a public purpose. This is lawful expropriation, but it has to be accompanied with compensation. You can't leave a person high and dry, take away the investment and wipe them out. Next, full protection and security. The host state has a positive obligation to take steps to ensure the physical and potentially legal protection of investments. It must prevent the physical destruction of property by taking measures that fall within the normal exercise of governmental functions of policing and maintenance of law. Obligation is one of due diligence and not strict liability. Then the next one is no arbitrary or discriminatory measures. An obligation not to impair the management, operation or use of any investment by arbitrary or discriminatory measures. In the sense, you can't discriminate between the nationals of one state and the nationals of another state. Arbitrariness is a willful disregard of due process of law, an act which shocks a sense of judicial propriety. Discriminatory intent have measures being taken in light of an investor's nationality, because that shows a willfulness. Discrimination in effect, a measure which in effect results in differential treatment to an investor than that accorded to investors in similar or comparable situations. Tribunals generally prefer an approach that looks towards the consequences of a particular action rather than focusing upon discriminatory intent. Is, for instance, you place an embargo on the nationals of one particular state, but let other nationals of other states come in and make that investment. So that's discriminatory on the basis of nationality. Then national treatment and most favored nation. Foreign investors receive no less favorable treatment than nationals within the host state. That means you can't discriminate between entities within your state and entities who come from overseas. They must consider the protections afforded to nationals of the host state. MFN accords foreign investors of the host state treatment no less favorable than third parties. Now I am going to come back closer home, which is white industries and its aftermath. And actually, frankly speaking, this is the reason why I decided to choose this topic to speak on it, because it has become a matter of serious concern, having huge financial implications for our country and our people, as 23 BIT claims have been made against the country. And it started from white industries. This was the first award which was passed in November 2011 against India for having delayed in the enforcement of an ICC arbitration award which came in favor of white industries, which was an Australian company. And we, of course, the government of India paid up 4 million Australian dollars. And the interesting part of it is that immediately after this award was passed, Australia scrapped its BIT regime itself, because they realized that they could also become vulnerable, and after that they have come out with a very guarded BIT regime themselves. It's not only developing countries, it's developed countries also which are concerned, because there are huge claims which are being awarded. In fact, recently there was a $50 billion award which was passed against the Soviet Union, which has now been stayed. But that is the kind of magnitude of amounts which are awarded by these bilateral investment treaty tribunals. Now, I have written here that India today is one of the most sued states. We have terminated our BITs with 59 countries, and we are in the process of terminating the existing BITs with other countries also. We've come out with a new model, BIT 2015, on the basis of which we now want to enter into fresh treaties with most countries from where we receive foreign capital, and also India also does export foreign capital, and it carries out development in the lesser developed countries across the world. So India is actually both an importer and an exporter of technology. Now, the critique of private arbitrations has been, in fact, why is India doing it? It's not only India. There are a whole host of European countries. As I mentioned to you, Australia, there is Poland, there is Romania, Latin American countries, African countries, Indonesia. There are several countries around the world which have become very critical of the investment treaty arbitration process, because the governments of the country have no role to play. It is passed, these awards are passed by these tribunals overseas, and I just told you all the fora. There are about 8 institutions in the world which conduct these arbitrations, and the criticism has basically centered that there is actually no law precedence in these arbitrations. They are ad hoc. So there is inconsistency in the awards passed by different tribunals. There is lack of transparency, which is very, very critical. Why? It has a public dimension to it. If this award was passed of white industries against Government of India, it's not Government of India just doesn't pay it. It goes out of the taxpayer's pocket. So there is a public dimension to it. There was a recent case of Philip Morris versus Australia, wherein the Government of Australia had carried out certain protections which were environmental in nature. This was against the famous cigarette manufacturer, and Philip Morris went and sued Australia for this. They said, no, we have a BIT claim. When we were manufacturing cigarettes, this was the kind of packaging, you can't unilaterally go and change it. They lost the case. But on these important issues, whether it's environmental issue, development of your country, because that is a sovereign power which no one can undermine. So these are issues which are of concern, that there is a tribunal which is conducting the arbitration. It's completely confidential, but it has a public dimension impact. So this lack of transparency has been an important issue of criticism. The third thing is that people feel that the persons who are appointed on these tribunals, they have been revealing a bias in favor of foreign investors. The larger claims they go, the more they get appointed in more and more BIT arbitrations. And fourth is, there is an expansive interpretation which is given to investment, which enables investors to indulge in treaty shopping. Now I will explain it to you. There was recently the case of Vodafone. Vodafone had acquired Hutchison SR, which was a company incorporated in India, but they had gone, the transaction was transacted in Cayman Islands. Now when they went to Cayman Islands, Government of India said, nonsense, this company is incorporated in India, you have to pay us, you have to subject it to tax. So they went and challenged it. The Bombay High Court Justice Chandrachud was that time heading the bench in Bombay High Court, had allowed it in our favor. Government of India won. An appeal was filed. It came to Supreme Court. Government of India lost. Then Government of India came out with a retrospective clarificatory amendment, because they said that more and more foreign investors will try and dodge the Indian tax authorities by going to Liechtenstein or Cayman Islands, entering into the transaction, but it is a transaction with respect to a corporation which is incorporated in the government, in our territorial jurisdiction. So a bilateral investment treaty arbitration was initiated by Vodafone, saying that you cannot make this claim against us. So they filed a claim under the India-Netherlands BIT. When they felt that the investment would not be covered by the treaty itself, they have in 2017 initiated a second BIT under the India-UK BIT, because it was far more wider. It was far more expansive. That was India's first BIT. So they have now gone treaty shopping. They have got another entity from their group to file another claim against the Government of India under another BIT. So they have gone really treaty shopping. So this has been a matter of serious concern, and there was an anti-suit injunction which was passed by the Delhi High Court, which subsequently got vacated. But this is an issue of treaty shopping which has been a criticism, because these tribunals have been giving a very expansive interpretation to the protections provided under the treaties, and permitting foreign investors not only to confine themselves to the treaties with which the Government of India has entered into an agreement with their home countries, but also they have been hopping and going to other investment treaties. So that we feel has been a very serious criticism by developing countries of this mode of investment treaty arbitration. Now the European Union has showed serious concern because of all these reasons, and they have suggested the setting up of a European investment court having arbitrators who will also represent the interest of developing states, because it's mostly developing states which get sued, because that's where foreign direct investment flows. So they have been suggesting this, and this is being mooted. So that actually is the current position with respect to investor treaty arbitrations. So this is an overview which I thought I will give you all today, and if you all have any questions, I'll be happy to answer them.
Thank you very much, madam. So nice questions.
Ma'am, can you please take us to that place where we have talked about the 8 forums?
Yes, fora. Just put that to fora. Yes. There are 8 institutions. Yeah, this is it. Investor-state treaty arbitrations are conducted. The most popular is ICSID, which is under the Washington Convention. It's actually attached to the World Bank. The second is an additional facility where one party is not a signatory to the ICSID Convention. The Stockholm Chamber of Commerce, the ICC, LCIA, PCA, and ad hoc arbitrations and SIAC. These are the 8 fora. Any other questions if anyone wants to ask me?
Chauhan? Anybody? Inakshi, yourself you have to ask something.
All right, thank you.
Thank you very much, madam. So nice of you, really. You are the second senior advocate woman lawyer addressing this Friday group.
Thank
We are
you.
really overwhelmed with the way you given time and so sincerely.
Thank you.
We give
Thank
it on unexplainable happiness
you.
we have. Once
One
again,
kind
thank
of
you.
request, ma'am, can we have it uploaded?
They are uploading.
Uploading,
They've
yeah.
taken it down. It's being recorded. So they will. Doesn't
I
matter.
think finally I'll give Inakshi Padya a vote of thanks now.
Thank you, ma'am, on behalf of everybody present here and others who are not present also, for all the trouble that you have taken in making this for us. It's really, we learned something, but my case, everything, it's 50% of it has gone out. So
In fact,
until
it's a very
unless,
new topic.
it's a very
That's
new
why
and we are
Not
not.
a very difficult,
Ah.
but now at least it's somebody talking about, we have some idea and now we can read
So
our
until and unless we read it again and again during vacations and all, so.
That's why I thought I'll introduce a new topic.
Yeah, it's very
entirely
good.
a
It's
different
a-
topic.
And it's of
Something
great
very-
relevance to the
that's
government of India. We have the largest number of claims today against us.
Yes. If by any chance, if we can get your help and access into any of these areas, so it will be a great advantage in this thing for all of us. Thank you, ma'am, for all
Thank
the
you.
support. We'll expect all further supports from you, from seniors like you, from
Thank you.
knowledgeable persons like you. Thank you, sir.
Thank you, madam. Signature here.
Off kar do.
No, no, you can write any message.
No, but when you are reading नहीं but ये है जिससे
हाँ? अच्छा नहीं ना ना कहाँ है वो
Read it and I think better.
Just it's very short and nothing.
Better. Message, Madhurima, once. Message, madam.
It has been my pleasure to deliver a lecture on investment treaty arbitration to a very attentive audience, and if anyone requires any help on this, I would be most happy to provide that to you.
Madam, kindly join for a cup of tea.
Because it's an arbitration,
Oh, yeah, an arbitration.
because I'm the arbitrator there.
Sure.
Thank you.
Thank you very much, madam.